Greetings, everybody, and welcome to Consumer Financial Services Outlook 2025, coming to you from Washington, D.C. I'm Jonathan Pompan, and I'm joined by members of our team here at Venable. Sarah Donovan. Sarah?
Thank you, Jonathan.
Andrew Biggert.
Hey, hello everyone. Welcome.
Chris Boone.
Hey, everyone.
And Connor Webb.
Hello.
And most importantly, all of you today are here, and thank you so much for joining us, for making time in your day, whether you're watching live or on playback. Now, before we get started, we do have some housekeeping to tend to. And specifically, if you're watching us live, there's going to be the option today for CLE credit, and we're going to get to that in just a moment. Also, this session is going to be recorded and will be available at venable.com later this week and on YouTube. The presentation is for general information purposes only and does not represent and is not intended as legal advice or opinion of Venable or any advocacy or representation on behalf of specific clients, and should not be relied upon as such. Of course, legal advice can only be provided in response to fact situations, and we should make note that today's topic is extremely fluid and things are changing rapidly. So stay tuned, but also recognize that this session is being done on February 5th, 2025. Now, today's session is live and is eligible where approved for CLE credit. A code will be distributed at the end of the session and program today, and also about halfway through. So take note of that code if you're interested in CLE credit and you're watching live. There's also going to be a CLE submission form that will be sent to participants via email after the session, along with the slides as well. So that's important for those that want CLE credit, and keep a watch out in your inboxes for that. Also know, too, that it may take us just a little bit of time to send that out. Now, here's how today's program is going to go. We're going to start with a discussion by all of the different panelists today. You've just met them, and we're going to meet them again in just a moment. The themes we're going to cover today are going to be varied, and whether or not you're involved in consumer lending, origination, advertising and marketing, servicing, all the way through to debt collection and debt relief, as well as also even possibly with respect to issues related to investing and fintech, we're going to cover as much as possible today. But the topic today is extremely broad. And so as a result of that, please take note that this is not going to be an exhaustive session, but we are going to cover as much as possible. We're going to go through the new Congress and the prospects for reform given the new presidential administration under President Trump, CFPB and the regulatory outlook and really the future of consumer financial services law, banking and fintech developments, payments updates and trends, cryptocurrency opportunities, which is one we want to highlight because not only is it a hot topic, but it's one where there's a 180-degree shift in government regulatory posture. The new FTC click to cancel rule, which is something that could end up biting a lot of folks out there. We want to make sure people are aware of it. State regulatory update and trends, and some closing observations. And now with that out of the way, we'll turn it over to Sarah Donovan in our Legislative and Policy Group. Sarah?
Thank you very much, Jonathan. I'm going to give us some context today on our current political environment in DC, and that's going to set the table for some of the actions that we've already seen from the administration and Congress, and then what we could also see in the very near future with regards to financial services. And I think it's important to really start out with the biggest point here, which Jonathan alluded to, is that dynamics have really changed on a lot of topics with Republican control of both chambers of Congress and the administration. We still need 60 votes in the Senate on most pieces of legislation. I'll touch on the exceptions to that a little bit later, which are reconciliation and CRA. But there really seem to be some shared priorities, not just between the House and the Senate, but also between Congress and the administration, which is a bit of a divergence from the past 4 years. So despite GOP control, I have to underscore that even things like crypto, with regards to congressional action, it still could be a little tricky to get things done because, as people say, everyone wants everything. Crypto really spent a lot on the presidential election. This was a very heavy hand by the industry. And like Jonathan said, it's a very hot topic. There's a lot of people across the administration and in Congress that are very interested in this that maybe weren't as dialed into it before. And I also want to take a little bit of a step back before I get into more specifics, both on crypto and some other topics. And that is, in general, it's going to be tough to get things done in Congress. You might think that that's a bit of an odd thing to say, given Republican control. However, there are historically narrow margins in the Congress, particularly in the House. This is the narrowest it's ever been. And it's an unwieldy conference, even if it wasn't a one vote margin, which is effectively what they're operating with right now with some vacancies. So this conference is a little tough to wrangle and to get enough votes to pass anything. And we did see a model for success under Speaker McCarthy, if you recall, which seems like 100 years ago at this point. But in the early days of the speakership, the conference functioned in the House a bit like a coalition. And he brought what I like to call the five families together, mafia style. There was representatives from these various factions within the conference, and he would bring them together literally into the Capitol, and they would meet at least weekly and talk about the various issues. And what that did was it fostered trust and communication amongst these different groups. So that's not really what Speaker Johnson has done, but we know that it can be done and it can be effective to pass big pieces of legislation. So beyond crypto, it is hard to tell what could get done at this point. And we can dive in with a little more detail, at least from the House side at first here. We've got French Hill, who is the new chair of House Financial Services Committee, and Maxine Waters returning as ranking member. They both have a long history of working together. I'm not going to get into that here, but it's certainly a friendly enough and a functional enough relationship. He is the first former banker, to lead the committee in more than 100 years, which I think is noticeable. He also believes it gives him these, what he calls practical hands-on experience when it comes to these various issues. I laid out a couple priorities here. This is obviously not an exhaustive list, but a few that we want to call out. On crypto, we're thinking, they probably legislate on market structure and stablecoin. You'll hear more about that. There's a whole section on this. You'll hear more from my colleagues later on that. Chairman Hill and Scott in the Senate with the agriculture committees, they're a little more ready to go on stablecoin, and the administration may lead on market structure. I mean, this all remains to be seen. Recently, I want to call out, there's a press conference with the crypto czar. This is in the administration. David Sachs, the Republican chairs of the 4 key congressional committees that are going to be acting on crypto. That's the banking, House Financial Services, and ag. And the idea for this is really to emphasize the close working relationship between the administration and these members of Congress, their committees of jurisdiction on the Hill. There is agreement, and Sachs laid this out, the need for new laws to support the U.S. digital asset market growth and ensure that the U.S. can innovate in the way that they think is necessary. He did not get into policy specifics, but according to the members of Congress that were at the press conference, that they're going to rely on the new Haggerty bill as the basis in the House and the Senate. And they emphasize they're forming a working group to work together across both chambers, coordinate bill writing, that sort of thing. So just this emphasis on coordination, I think, is a marked departure from where we were before. Hill's continuing to talk about market structure. He's really focusing on debanking in the early days of his chairmanship on the House Financial Services Committee, scrutiny of regulators and their role to play in all of this. So there's a clear desire here, in my view, to clear the decks, turn the page. There's been so much work on this done over multiple Congresses. Let's do this. So we'll see. Another focus for him, make community banking great again. He put out a memo last year on this. He's doing hearing this week on it. So clearly another theme for Chairman Hill in the House. And then, there's some other things here: affordable housing, CFPB reform, transparency. These is not an exhaustive list, but a couple things we want to make note of. And then so with that, Jonathan, I'll move on to the Senate. So you'll see here again, I didn't want to do like a laundry list of all the priorities they said. I don't think that's necessary. I think we really want to focus on what's top of mind and what's coming first here and what's a little more known. And so he does have some shared priorities with Chairman Hill on things like crypto, affordable housing, increasing access to capital, oversight, those sorts of things. I will note this, though, on the Senate side at least, Chairman Tim Scott is also chairman of the Republican Senatorial Committee. This is the campaign committee that is focused on electing Republican senators. So if any of you are familiar with like the RNC, DNC, there's one of those for the Senate as well, both parties. And he's also chairman of that. So how will this impact his time and his attention? It's a very time-consuming political role for him in the party. We'll see. I suspect the House will drive a lot here. On interchange, something, a lot of people ask about all the time. The Senate is still driving on that issue. Supporters are going to continue to try to attach that to moving bills, regardless if they're germane or not. And so if that is something that you're following, I would say no one should really let up the gas or, take their eye off the ball on that one. I want to talk about how Ranking Member Warren and some other Democrats in the Senate, including Bernie Sanders, are trying to tap into this populist streak that's really been having a bigger impact in the Republican Party. And so kind of how do they tap into that, like from a political perspective and then also from a legislative perspective? Senators Sanders and Hawley just introduced a bill this week, I think it was yesterday, capping credit card rates at 10%. So you're going to see kind of some more of that. Do they try to trap Republicans on some populist issues? Like, how do they take advantage of this? That'll be really interesting to watch. We'll talk a little about reconciliation, which could frankly be its own webinar. I will say this: it has been underway in Congress for at least the past 6 months, really working hard to figure out what to put in it, top line numbers, the whole deal. This is really in flux. I think what's notable here is that both House Financial Services Committee and Banking are going to have titles in reconciliation. What is in those titles is currently unknown. They're dealing with some big picture items still. They haven't drilled down into the specifics. There is a menu of options. I would expect, I wouldn't be surprised if something with CFPB ends up in there, but as of now, we really can't say what will be in there or not. And then of course, CRAs. This is Congressional Review Act, resolution of disapprovals. Two things that are ripe, CFPB overdraft rule and medical debt. I don't know if either of those will come up. I suspect maybe the CFPB overdraft rule, possibly, so we'll keep an eye on those for you as well. And then on the last slide, and I will do my best to do the hurry up special, Jonathan, here. These are some overarching things of the administration. I think we've all seen this already with the executive orders: dismantling DI bureaucracies, deregulation, and themes that efficiency and that sort of thing. American competitiveness, I mentioned before, crypto is involved in that, and so many other things. The sovereign wealth fund. So these are really some big overarching principles that we can then see trickle down into these specific issue areas. Administration has already taken a lot of action. They put out an EO on crypto, regulatory freeze, rescission of DEI programs. They put Treasury Secretary DeSent over at, as acting head of CFPB. So really off to the races in a number of areas here. Just to leave you with one more tidbit. We started to hear yesterday morning that there's something coming, an executive action of sorts on CFPB. I have no details on that, but given the magnitude of the actions we've seen thus far, I would not be shocked to see anything, anything anymore. But that's the latest rumor, that there could be executive action forthcoming on CFPB. And with that, Jonathan, I'll turn it back to you.
Well, thank you, Sarah. And yeah, with that, anything's possible. So what we're going to be discussing now, of course, is the Consumer Financial Protection Bureau, and really the future of consumer financial services regulation and policy in the United States. A lot of this is in flux, folks. I don't need to tell you that. You've been reading all of the headlines. We're going to hopefully provide a little bit of context for what's happening here, possibly what changes could be in store and different approaches that could be taken. There's really, at this point, a fork in the road opportunity for the administration. Does it do something similar to it did in the last Trump administration, where the Bureau ultimately continues on, perhaps in a deregulatory mode, but nonetheless is a functional agency, or are there other changes afoot? And a lot of that is TBD. But for now, at least, the latest news, of course, is that President Trump has put Treasury Secretary Scott Bessent in charge of the Consumer Financial Protection Bureau on an acting basis. And that's 2 days essentially after firing Rohit Chopra, who was nominated by former President Biden and was serving his 5-year term, which was set to expire late in 2026. Trump named Bessent as the Bureau's acting director, really after Chopra got an extra week and a half or so in the seat at the CFPB and didn't let up until the end. Now, certainly November, December was very busy, and so was even January for the CFPB. A lot left there. But most importantly, before we get to some of that, Director Bessent said he looks forward to working with the CFPB to advance President Trump's agenda to lower costs for American people and accelerate economic growth. He then went on to send a message to staff, essentially to pause much of its work. And that's not that different than what happened when in the first Trump administration, Mick Mulvaney was brought in. He was the head of OMB at the time, Office of Management and Budget. He was the acting director as well of the CFPB. And at that point in time, he ordered essentially a pause on all of the activity as well. Now, what does that pause mean? Now, for folks that are in the thick of it, it means different things. For organizations that merely are looking at this from a compliance and prospective standpoint, it might mean something different. But first and foremost, there's an impact on proposed rules, final rules, as well as also that are not yet in effect, is also, of course, informal guidance. There's no new investigations to be launched or activity on present investigations, or even settlements that may be in the queue that may have been started. And you certainly saw quite a few settlements at the beginning of January and really starting in December into January, and in fact, actually leading up to Chopra's firing. There's also, it's supposed to be no public official communications from the Bureau that would include reports that may be in the docket or in the queue to come out. No formal agreements with respect to staffing as well as contractors or anything of that nature. And then no filings or appearances in litigation except to pause litigation. And that's interesting because that's actually already unfolded already. Just earlier this week, within hours of this message going to staff, the Texas Bankers Association, which is litigating in the Fifth Circuit, the small business minority data rule, essentially argued one-sided. Just it and the court, CFPB had to step up and just essentially say, Your Honor, we need to pause because that's what we've been directed to do. And at this point, we expect that to happen in multiple cases that are pending, some of which are proactive from industry. And some of those cases, though, are enforcement matters. Now, what does this all mean? The future with new management is going to be one, again, where there's a fork in the road. There's the potential here for this to go a lot of different directions. First and foremost, Project 2025 as a line item has Congress abolishing the CFPB. And short of that, it has funding to be canceled out for enforcement matters, except ones that were done through proper administrative use of the law. Okay, setting that aside, if it doesn't get that far, then you've got a question of how will Bessent operate the CFPB going forward. And if passed as prologue, we know that personnel changes could be in store. There are a few holdovers in some senior positions, at least as of earlier this week, that certainly would be let go and replaced. And then you also have other aspects of personnel impacting the Bureau. Ever since the Seal of Law decision, really personnel is policy at the Bureau. So that's the open rulemakings and lawsuits challenging the rules. They certainly could be settled in more favorable terms. The rulemakings could be rescinded or reopened potentially. With enforcement, we're already seeing a pause that could actually have much more longer term implications, although the devil may be in the details on that. And the real question, though, the open question in terms of what was included in the laundry list of pause items, there's something that was not included, and that's the future of supervision and examination. That is an open question, TBD. Certainly, it's potentially possible that supervision and exams in the long run continue, but take less of a broad and aggressive view when looking at facts and circumstances of organizations subject to supervision and exam. Should be noted too, the FTC is also under new management. FTC has jurisdiction over many of the consumer financial laws as the CFPB enforces as well. So there is, again, the potential for someone else, theoretically, to pick up the ball from where the CFPB is. But of course, from an overall Trump administration perspective, don't look to see necessarily any regulatory agency, independent or otherwise, pushing forward in the same way that it's been over the last 4 years. Now, again, there's also long-term questions that have been percolating for quite some time about the future of the CFPB, including litigation about whether or not its funding is unconstitutional, not the one that the CFPB prevailed on, but rather whether or not profits from the Federal Reserve is in fact actually anything at all, considering that they've been essentially zero for some time. So that's a question that's percolating in the courts. The Bureau could step in and weigh in on that question, of course, as well. Although there's other ways too, of course, that the management of the Bureau can reduce, restrict, or eliminate the functions of the Bureau going forward. Now, there is the question too of some of the stuff that Chopra did at the end. We're going to get into some of those items in a moment, but most importantly, he put out a compendium of recent CFPB guidance. His general counsel, Seth Frotman, put out a compendium of all the different advisory opinions and interpretive stuff that the Bureau has put forth over the last 3.5, 4 years. That will fall by the wayside at the current Bureau, but importantly, it is either a lasting legacy or a last gasp of the Chopra regime. We have an article on our website about that at venable.com. And we also have an article too about something that took place actually 4 years ago. At the end of the Kraninger CFPB, they put out a report from the Task Force on Federal Consumer Financial Law. That report has over 100 different recommendations, some of which Congress would have to implement to change and modify all aspects of the CFPB to better orient it both with what the vision under Dodd-Frank would have been, but also to depoliticize the progressive nature of the Bureau. It's an important report because it could end up being a blueprint for some of the changes that will be implemented at the Bureau on a go-forward basis. We're also keeping an eye, as Sarah said, on the Congressional Review Act. That's got a 60-day window. We're some days already into that because of the legislative calendar. And there's some rules that are potentially ripe for review. They're also being tackled in the courts. Now, there's a laundry list of government regulations, official regulations, final rules that were promulgated by the CFPB that will take effect later this year, including the 27 payday rule and some others. Those are subject to potentially being paused, or they are paused now, but long-term pause, revisited, reopened, possibly even being rescinded In a lot of cases, some of the stuff is based on stale information that the prior bureau would have used or relied upon. And at this point, we'd probably be ripe to reopen for consideration regardless. But BESINT for now has paused. There are some stuff that has come out really relatively recently that are left for BESINT to work through, decide if they want to continue with or not. In many cases, they probably won't be. But that's a rulemaking on prohibited terms and conditions and agreements for consumer financial products or services. There was an RFI regarding the collection use of data and personal financial information. There's one with respect to marketplaces, crypto, and other payments that is going to apply Regulation E and the Electronic Funds Transfer Act to that to those products and services. It's an important one from a liability standpoint and a compliance standpoint. From an interpretive position standpoint, it was really indicative of where the Bureau had been already, because there was a parallel enforcement matter that sort of applied that principle already. But that's ripe, of course, for being rescinded as well. There's other ones too. There's a laundry list on this slide, and in the materials we have some materials on our website as well. But stay tuned on that, because the pause right now is just a general pause. The real question will be is there any specific action taken to any one of these or more, or if there's going to be some sort of blanket rescission where possible. Now, you also have coming up too, and for some companies, essentially the effective date has come and gone with respect to making a submission on the non-bank registration portal and public database. That database, of course, was viewed as the Scarlet Letter database, one that would collect up enforcement matters under UDAP statutes across the states, as well as federal statutes that were specified, and create a one-stop shop for finding enforcement matters around companies. It was a broad database, although it didn't necessarily capture every regulatory action that could be taken. The question there is will it continue or not? It's a very controversial. A lot of organizations, though, have already had a time period come and go with respect to submissions for larger participants. And then now we're in the period for other CFPB supervised covered non-banks as well. So you've got this in progress database. The database portal has been up and running for some time now. And you also have a scenario where that registration has a different kickers as well for annual checkups and whatnot. So it's going to be interesting to see how that unfolds, and keep an eye on that as well. Certainly, we've had lots of discussions with clients that are finding themselves sort of caught in the timing here. And it's one that I think will be interesting to see just generally how it unfolds, but also specifically for companies should give consideration to that. Also, at the end of the Chopra era, you had two parallel announcements around no action letters and also a sandbox approval policy. They were essentially similar, and they really lay a marker down, but one that is not particularly really all that useful for industry. You had in its current form, the form that Chopra had written, you have both a no action policy and a sandbox policy that would subject companies participating into examination and supervision posture with the CFPB. You have an opening of the kimono requirement where organizations would have to essentially share information more broadly on behalf to their competitors, not just identify who those competitors were. There was a prohibition on using certain lawyers to assist and engage in that process. A whole slew of things that really would put a straitjacket on anyone participating in this process. That being said, sandbox and no action was a component of the Kraninger CFPB. And to the extent the CFPB continues and wants to open up to entrepreneurship and innovation, the concept of no action and sandbox could be really useful on a go-forward basis, perhaps just not in the format that it is now. Now, the big question is, of course, is sort of where are things headed? And again, as stated, it is very much a work in progress on the part of the administration, with announcements that could be happening even while we're speaking right now. That being said, regardless, there are pending enforcement matters in litigation that are going to be subject to review. Mick Mulvaney, when he took over 7 years ago, talked about having a stack that he had to work through. Well, that stack got bigger during the Chopra period, and there's plenty to do. Big box stores, major payment platforms, digital platforms, and others were all the recipients of complaints and being hauled into court at the end of the Chopra era. And in some cases, there's been cases that have been pending for quite some time. The question also then becomes, what's the future of examination under the supervision framework? And that future is likely one that, to the extent it continues, it'll be much more restrictive. What I mean by that is that in scope, it'll be fewer organizations. The larger participant rulemaking that was proposed by Chopra probably going to fall by the wayside. And you're going to see more of a focus on organizations that maybe are already subject to supervision, but that cadence will become a longer period of time in intervals, much more of a risk-based approach where not everyone needs to be examined all the time, and a scenario where you might see less overlap, particularly banks that are already subject to supervision by the prudential bank regulators. Do they really need to be examined also by the CFPB? Those are going to be questions that are up for and ripe for consideration. You also probably see credit by organizations being rewarded more. And credit meaning proactive compliance steps, remediation, other steps that are taken either during an exam, anticipation of an exam, or even after an exam, rather than the sort of approach that the Chopra administration took, which was thanks for fixing that, but we're also going to slap you with an enforcement action. So we'll probably see that dissipate quite a bit. Responsible business conduct will be likely rewarded, and certainly is something that companies should consider in terms of the strategy as well as the tactics, and of course, good business and doing right by consumers. The examiners also have tended to focus on compliance management systems, and we're going to see likely less of a focus on that to the extent exams continue. It's all going to be about technical compliance with the requirements under law. Now, that's important because under the Chopra and Cordray eras, compliance management systems in some cases served as a proxy, and then also the interpretive opinions and other guidance that was given to the marketplace trickled down to the examiners, and you had aggressive positions on technical compliance as well. Likely to start to see less of that, but it's important to keep in scope that just because there's going to be a deregulatory posture at the Bureau, it doesn't mean that these consumer financial laws cease to exist at all. In fact, actually, many also have private rights of action, of course, and can be enforced by state AGs as well. We'll touch on that in a little bit. Now, there's also, of course, Supreme Court activity. This floats into how the future of some of this legal stuff pans out with respect to the challenges in the court cases. It also translates, though, into some of the rulemakings and whether or not the rulemakings perhaps need to be continued, but perhaps need to do a 180 pivot in terms of the policies that are interpreted. And the question is really going to be also, too, under Loper-Bright and the CFPB, is where were the rules written, the ones that have been on the books for a while, not the ones that are necessarily in the hopper now, but not yet effective. The ones that have been on the books for a while, were they done under the UDAP authority or some other authority of the Bureau? And then how does that play out in court challenges that may be brought by individuals as well as perhaps the agency, but less likely now? And with that, we'll turn to my colleague and partner, Andrew Biggert.
Great. Thank you, Jonathan. And over the next couple of slides, we'll talk about some developments in banking, fintech, and payments. And while we're certainly doing a lot of forecasting here in terms of what we expect moving forward, I think at least in this area, it's helpful to look and see what happened in the 2023, 2024 time period and how some of those developments are likely to continue moving forward. And at least on the kind of the banking side, and particularly bank fintech partnerships, a lot of scrutiny really increased in that time period. We saw the banking regulators following some of the bank failures, some large fintech middleware company bankruptcies, take a much closer look at banks and how they partner with fintechs to provide various different types of financial services. This really wraps in at the exact same time with an increased focus overall on third-party risk management. And we saw this really being stepped up, not just in enforcement, but also in the supervisory area. And I think while a lot of how the Trump administration will address these issues, remains up in the air, and obviously there's been a lot of fast-moving developments, I do think that we're going to continue to see a focus on third-party risk management, at least at the kind of supervisory levels. And what we've seen is in examinations, the Fed, FDIC, OCC, they're really going in and looking at how do banks partner with fintechs. What kind of policies and procedures, getting very granular in that area. Looking at their contracts, how have they flowed down compliance obligations? How are they managing AML, data privacy? All of those issues are being looked at very, very closely by the regulators right now. And while they've been doing that kind of on the ground through day-to-day examinations, there's also been a lot of guidance and proposed rules that have been issued. The agency's issued an RFI and guidance generally on bank fintechs that really, while recognizing that they have many benefits, also flags that they can present a lot of risks. I think one of the challenges with the guidance, and I think was reflected in a lot of the feedback on the RFI, is that bank fintech relationships, there's a lot of diversity, a lot of variety in how they're structured, the different products and services, and you can't really have a one-size-fits-all approach. And so we'll see how, if any of that feedback is taken into account moving forward. There's been a lot of enforcement actions in this space too, kind of complementing not just the examinations and the rulemakings and the guidance, but also through enforcement actions. All of these, and we're not going to go through these, but we're all focused on kind of third-party risk management of fintech partners. Go to the next slide. On the rulemaking front, a couple of rules we just want to remind everybody have been proposed and are still in play, but we will need to see how the new administration ends up dealing with these. You had the FBO account rulemaking, which the FDIC issued last year, and comments actually just closed January 16th, I believe. But this essentially will establish record keeping and some other technical requirements for banks that are offering fintechs and other third parties access to custodial deposit accounts, also called FBO accounts. And these are the types of accounts that have been used by fintechs, almost all types of partnerships for a variety of reasons, including to, in some cases, minimize the fintech state licensing risk, whether it money transmission or even in the lending space, for example. Next slide. Kind of also at the same time, proposed rule was issued on broker deposits that would return to kind of a more conservative approach in terms of expanding the types of entities that could get pulled into the broker deposit regulation. This is a rule that has gotten a lot of pushback from industry, and it would certainly impact fintechs in a pretty significant way that are working with banks, moving funds on behalf of different clients and having those funds go to banks could get pulled into this rule if it is finalized. So that is definitely one that I think we'll get a closer look moving forward. Next slide. The CFPB also finalized their 1033 open banking framework. So this is in the course of being rolled out. And as I'm sure many of you have been following, I mean, this is a rule that basically gives consumers control over data, certain types of data that are held at their financial institution, so that they can share that with third parties. If they're trying to access other services through a fintech, for example, they can authorize their bank to share data that fintech can then use. So this is in progress of being implemented, and is certainly, I think, going to impact how a lot of services are provided in the market moving forward. Next slide. The another just on the AML side, and something to just keep in mind is that the Corporate Transparency Act did come into effect and requires companies in the US, if not exempt, to file their beneficial ownership information with FinCEN. And from the financial services perspective, if you're a bank or another type of FI, having access to that database, how you're supposed to use that information is going to be very important. FinCEN is still working on a rulemaking for how banks can kind of use this information for their customer due diligence. But in the moment, it has been challenged in a number of different lawsuits that are working their way through the appeals process. And for the time being, FinCEN has stayed kind of the beneficial ownership reporting rules for companies. So keep an eye on that and see how that litigation ends up netting out. Next slide. So very quickly, just to touch on a couple of payment topics. We expect to see cross-border payments grow in popularity and scope this year and moving forward, especially on the B2B side for businesses that are selling internationally. There's a lot of companies starting to find ways to serve them and help them operate on an international basis from a payments perspective. We'll talk a little bit later about cryptocurrency, but some of the areas that we've seen growth are going to continue to grow: account to account, real-time payments, et cetera. Regulatory reforms, Durbin Amendment and Reg II, there continues to be, outstanding kind of rulemaking on potentially lowering the interchange cap. A corollary on the credit card side, there are bills that have been introduced that would apply Durbin type provisions to the credit card market that are getting, pretty significant input from banks and from merchant groups. So those are two areas that could have a pretty big impact depending on what direction both the Fed and Congress go on that. But next slide, there's also been some developments worth monitoring at the state level. Illinois launched a law that would prohibit payments companies from charging interchange fees on tax and tips, which creates a lot of technological and practical challenges. That's subject to litigation that is ongoing. But in the meantime, 2 other states have also announced similar types of bills. So this could be kind of a new front at the state level for payments companies that needs to be monitored pretty closely. And then finally, just a reminder that enforcement in the payment space continues, whether it's the FTC or the CFPB. During the prior Trump administration, these types of enforcement actions were happening. They continued through the last Biden administration, and I think you can continue to see them probably moving forward. So that, if you're a payments company, making sure you've got the right policies and procedures in place to manage risk and underwriting of your merchants, it's going to continue to be pretty important. And so with that, Jonathan, I think we can move to the next topic.
Thanks, Andrew. So first, the CLE code is Deregulation 2025, Deregulation 2025. So let's start with the big picture. The Trump administration is signaling a dramatic shift in the government's approach to cryptocurrency, focusing on reducing regulatory burdens, encouraging adoption, and just generally positioning the US as the, and I quote, crypto capital of the planet. It is really hard to overstate how significant of a shift this is. And it's not just words. We're seeing this being played out right now, this week, yesterday, and probably even tomorrow through executive orders, agency appointments, and other actions that are moving the US away from the restrictive measures of the Biden administration towards a much more open and welcoming, industry-friendly position. So the kind of key question is, how will this actually translate into regulatory action? And then simultaneously, there is a growing bipartisan consensus in Congress around the need for a thoughtful, innovation-focused crypto legislation. So the chances of crypto legislation passing this year is higher than it's ever been. And this includes general market regulation, and stablecoin legislation. Next slide. So we don't have time to go through all of the appointments, but these are showing a very strong signal of where crypto policy is headed. Just for one example, the nominee for the head of the SEC, Paul Atkins, has advocated in favor of cryptocurrency innovation and is expected to dramatically slow down enforcement actions that don't involve fraud, and expected to revisit the agency's cryptocurrency guidance, particularly regarding when a cryptocurrency is considered a security, which is very, very important for a lot of regulatory reasons. And while this confirmation process unfolds, pro-cryptocurrency Republicans will hold the majority among the SEC's politically appointed commissioners, and they are already poised to get the ball rolling on these kind of objectives. Just for example, today, there was reporting that the SEC has reassigned its head of litigation, who's been involved in a number of crypto-related lawsuits, to a position in the SEC's IT office, effectively ousting the litigator from effective kind of litigation enforcement-focused work. And there are also reports that there are many of the litigators that were in the SEC's cryptocurrency task force that are being reassigned. So, I mean, there are so many different agency positions that kind of mirror this general direction, but we don't have time to go through them all. So we'll go to the next slide. So Trump's recent cryptocurrency executive order reflects a fundamental change in how the federal government engages with cryptocurrency. It does a lot of things. It revokes previous digital asset executive orders. It creates a new working group to establish a national cryptocurrency framework. And interestingly, the order also firmly rejects any use of a United States CBDC, that's a central bank digital currency. Instead, the Trump administration is leaning into fostering private sector innovation and stable coins while developing a regulatory framework. Next slide. So right before Trump took office, the CFPB issued a proposed interpretive rule that would sweep stablecoins and cryptocurrencies that operate as a medium of exchange under the Electronic Fund Transfer Act and its implementing regulation, Regulation E. If adopted, this interpretive rule would significantly alter the compliance obligations of cryptocurrency-related companies, potentially requiring them to offer error resolution procedures, provide consumer liability protections, depending on the services that are provided. However, big however, with the change in leadership at the CFPB, the proposed interpretation could be withdrawn or modified or stuck in limbo. So it's really hard to tell at this point where that will go. Finally, as a result of the changing regulatory environment, we're seeing a shift. Foreign crypto firms that previously avoided the US or blocked US persons are expanding into the United States. But reduced regulation does not equal no regulation. Challenges remain. Crypto companies will still have to navigate money transmission rules, anti-money laundering compliance, and a patchwork of state laws. So to kind of wrap up the cryptocurrency portion, the big takeaway here is that the US crypto landscape is entering a new phase, one that's far more industry friendly, but still evolving rapidly. And the Trump administration's actions all point to a future where digital assets are more integrated into and supported by the traditional financial system. So with that, we'll move over to Connor to talk about the FTC's click-to-cancel rule.
Thank you, Chris. And we'll talk briefly about the FTC's click-to-cancel rule as the FTC's way of essentially codifying and expanding many of the rules around negative option marketing that it's developed through its enforcement actions over the last decade. It's a new rule that replaces an existing pre-notification negative option rule with a lot of requirements emphasizing disclosures of material terms, placements and formatting of those disclosures, consent requirements, and simple cancellation mechanisms. But its most notable feature is probably its very broad scope, which we'll discuss on the next slide. Business-to-business transactions are not exempt from this rule. The rule applies to negative option offers in any media, including telephone, online, print, or in person. The definition of a negative option offer is very broad. It's anything with an automatically renewing, any offer or agreement to sell goods or services through an automatically renewing agreement where a customer's silence or failure to reject the goods or services is interpreted as acceptance of the offer. The rule's scope essentially extends to the edges of the FTC's authority under the FTC Act. And moving to the next slide. Payment processors and intermediaries have a little bit of reprieve from the rule in that the FTC has agreed to an interpretation of the key term, negative option seller, that would allows it to not cover intermediaries merely affecting transfers of funds on the back end of a transaction process. That being said, the FTC has not extended that exemption or exclusion to anybody who is offering their own services through an agreement or offer with a negative option feature. So a payment processor or payments intermediary providing its own services through an automatically renewing contract may be covered. The FTC also made sure to warn about payment processors and intermediaries about their responsibilities for partners and vendors and ensuring their compliance as well, which we've seen through Section 5 of the FTC Act can result in enforcement actions. Next slide, please. Moving through to state regulatory updates and trends, we go to the next slide. We'll do a quick refresher on the many and varied types of state consumer protection laws, varying from general UDAP statutes enacted by states and enforced by states' attorneys general, banking and financial services regulators, and even sometimes class action plaintiffs. States also have some ability to enforce the consumer protection provisions enacted by Dodd-Frank, be that the more expansive version of the UDAP statute, or the more expansive UDAP statute included in that law, as well as certain CFPB rules and other more specific consumer financial services laws at the federal level. A key feature of state regulation, of course, though, is the licensing aspect for companies engaged in various forms of lending and loan servicing, whether that be mortgage or non-mortgage, money transmission, various debt-related activities, and often others as well.
And Connor, we're already seeing changes in those laws that are taking effect within weeks, like in California for debt relief services, a slew of changes in the money transmission world, and also tweaks to some of the mainstay mortgage licensing statutes as well. So that rubric, it becomes very important for day-to-day compliance, but also for like mergers, acquisition activity as well, because that's always an issue that comes up in potential transactions where you have questions about licensing and transfers of licenses and whatnot.
Absolutely. And on the topic of potential changes, Director Chopra's, I guess, parting gift to the states was a playbook on potential recommendations of potential ways that states could either legislatively or regulatorily enhance their consumer protection laws. A few of these are not surprising, such as recommendations on prohibiting junk fees or strengthening consumer data rights. But a few might raise eyebrows, such as incorporating the abusive concept from Dodd-Frank into states' consumer protection laws. There are suggestions on reforms to agency enforcement powers and private rights of action, at least one of which was aimed at arbitration clauses, and recommendations on expanding consumer protection laws into the commercial context, which is something we've seen come up a little bit in the lending context recently with laws in New York and Illinois that were considered by the legislatures but not passed, that would have extended TILA-like protections into business lending. Moving to the next slide.
Yeah, and that's right, Connor. And one thing that's also important, can't be understated, how much of the supervisory highlights and the interpretive guidance and circulars and other missives from the Chopra CFPB work their way into examination findings at the state level. And that, you know, we used to be brought in sometimes after the fact because what was not anticipated, where a state regulatory body would bring up topics that mirrored similar investigations or exam issues that we were dealing with for different clients from the CFPB. So I'd expect in some cases that this parting gift and others, including the compendium of circulars and the mindset of the Chopra CFPB, has migrated down to states when doing examination activity.
And that examination activity Jonathan spoke about from states, we're expecting it to get more coordinated through an approach called network supervision that's really been championed by the Conference of State Bank Supervisors over the last year or two. Network supervision represents an effort to bring together multiple jurisdictions, bank and financial services regulators, to help facilitate easier licensing and chartering processes and better uses of supervisory tools and processes. The network supervision has already shown some fruit in that regard with a large settlement agreement that was just announced between 48 state financial regulators and Block, the publicly traded company who owns Cash App, Square, and other large money transmission companies. The settlement agreement included an $80 million fine for issues with their Bank Secrecy Act and AML compliance, and it was led by Arkansas, California, Massachusetts, Florida, Maine, Texas, and Washington. Most of the states participating had also enacted a version of the Model Money Transmission Modernization Act, a model law created by the CSBS that really champions this network supervision approach through some of its provisions. Network supervision also has the benefit of simplifying licensing and chartering. It promises faster, better, more efficient licensing and chartering through programs such as the One Company, One Exam, and new processes being rolled out for more streamlined new license applications and reporting mechanisms. An example of where we think it could continue to, or where we think it will make future improvements, is with respect to change of control notice and approval filings. Currently, when you're licensed in multiple jurisdictions to perform money transmission, lending, or another regulated financial service, if you want to bring on certain new investors, change owners, or replace key individuals, you'll be going through a very piecemeal and arduous process to notify regulators of the proposed change and hopefully obtain their approval of the change before the transaction or change actually moves forward. Some of the improvements we've seen to NMLS in the last year have made it simpler to provide that notice to multiple regulators at the same time, but the act of actually getting the approvals remains piecemeal and fragmented in some ways. CSBS has already tried to approach that, or tried to solve that piecemeal approach problem in some ways through its model legislation, but as they work through more of the network supervision approach to examinations and other supervisory tools, we expect that they'll start leveraging some of those provisions in the model laws that allow for better information sharing and for regulators to rely on determinations made by other regulators, thereby simplifying processes for banks and other licensed financial services providers.
Yeah, and Connor, change of control is something we're likely going to be working through, and many of you, our audience, will be working through in the next coming years as M&A activity takes off. The requirements under the various different statutes, whether it be debt collection, lending, mortgage, and others like money transmission, vary considerably amongst the category as well as throughout the different states. The result is that oftentimes a big portion of getting ready for closing for a potential investment or an entire takeover of a company that it has licensees, whether it be a direct or indirect takeover, can require really strong and rigorous consideration of what those requirements are. And they may end up impacting structuring as well as also various filing obligations by the acquirer and its new management team, and potentially others involved in the transaction. And before we switch gears, should also note too that on the state front, there's a number of statutes that are percolating around essentially opting out of federal preemption for interest rates, which will drastically change the map for small dollar lenders if passed. Already, we've seen changes amongst several states in the last few years. And that continues to unfold. Of course, that affects banks as well, who sometimes have bank partnerships for lending activity, and whether or not their interest rates will then carry over to the prospective customers, the applicants and borrowers of the fintech. And with that, we'll switch gears now to our closing. And we really want to thank everybody for attending today, for your time, your patience, as well as also your commitment to engaging on these topics. They're very fluid. Keep your eyes open for more developments, including the upcoming reconciliation process in Congress, which could affect CFPB funding, as well as everything that happens between now and March when that will take place. I'd certainly like to thank our support team here, as well as also my panelists, Andrew Biggert, Chris Boone, Sarah Donovan, and Connor Webb. And please feel free to reach out with any questions. We'd love to engage with you both through the web as well as through email. We have a lot of content too on these topics and other topics at venable.com and coming to you with the email with this presentation. And again, it's what we do each day, but thank you very much for your time and attention to this. And with that, I will pause and give the final CLE code, which is Deregulation 2025. Thank you very much.